Thank you. Please be seated. Welcome to this special session of the Iowa Supreme Court held at Ames High School. And thank you for spending a part of your evening with us. We have one case that will be submitted this evening. That case is State of Iowa versus Kenneth Osborne Airy. And Ms. Huser, may you proceed?
May it please the Court, Counsel. My name is Kelli Huser and I represent the state of Iowa in this appeal. The district court properly denied the defendant's motion to remove the entire jury panel for two reasons. First, the defendant did not meet his burdens under either our rules or our existing case law to show that the entire jury panel was biased. Second, the Ninth Circuit case that both the defendant and the Court of Appeals relied upon is neither legally persuasive nor factually similar to the case at hand. I'd like to start with the presumptions that we are working with here. We presume that our jury is impartial, and we presume that they follow their jury instructions in the case. It is on the moving party to meet the burden to show that a particular juror is partial. One way that the defendant in this case could do that was through Rule 2.18, which says you can overcome the presumption of impartiality when you show that the juror has formed or expressed an opinion as to the guilt or innocence of the defendant that would prevent that juror from rendering a true verdict based on the evidence. The defendant has not met the burden in this case to overcome those presumptions. Prospective jurors in this case heard no less than 9 times during jury selection that they should decide this case based on the evidence presented to them on the witness stand. There's no evidence that any juror agreed.
I take it's the state's position that what this juror said wasn't enough to prejudice the panel. Do I have that right?
That is correct.
What would have prejudiced? What is enough to prejudice the panel if this isn't?
I think the rule that has been shown in our case law is that to show a particular juror is biased, you must show they are actually biased. And so we presume they're impartial unless you meet the burden such as stated in Rule 2.8.
Well, the court did dismiss this juror. I mean, found this juror to be biased, but if you read the Ninth Circuit case, what more did this juror have to say, or if anything, I mean, to poison this jury, or can a juror ever poison a jury pool?
No, I don't think a juror can, absent the moving party asking the question that we ask in all of these cases. We presume that the jurors are not going to automatically take anything anyone else says as fact. Instead, we ask them, can you nonetheless be an impartial juror and make a decision based on the evidence in this case, which the defendant could have asked the rest of the jury panel that question.
But the defendant didn't. Does that mean maybe we have to not reach the issue tonight and have it taken up on a PCR, post-conviction relief action?
No, because I think we go back to the presumption that they're impartial unless the moving party has shown that they are not. The fact that he did not make the burden in this case shows that he hasn't shown that they were partial, so we assume that they were impartial. And his inability to meet the burden that was set for him means that he got the process that he was entitled to here.
Well, let me ask about the law generally. And it seems to me that ordinarily, when a juror expresses a statement of bias or makes a statement about evidence that's not before the court, ordinarily, you're right. But as I read the cases, they seem to reserve an exception for what the courts have described as, egregious cases. The Mott case says if it's really strong, there might be, quote, structural error. And it seems to me the cases that I've read have generally agreed with you, but kind of reserved Well, but in extreme cases, the jury might well be tainted. And Mock was such an extreme case. Now, in Mock, you had someone who was familiar with some social science and was familiar with sexual crimes. Here you had a pastor who basically testified based on his pastoral experience. And then repeatedly said, well, I know that, there's all kinds of people that use drugs. They always lie. They've always done it. I've had hundreds, I'm paraphrasing, of course, but, it goes on page after page after page of this pastor kind of testifying before the jury. Tell me why this isn't one of those exceptional cases. I mean, it wasn't a snippet or two. I mean, it goes on page after page after page. Now, help me out.
Well, I think the key distinction in this case that's different from Mock is that Mock looked at it as this expert-like kind of statements. And first, I would disagree that this court should adopt any sort of expert-like standard. I do think the egregious situations you're talking about will be very fact-specific. But to return to the key distinction, I think when we're talking about experts, there has to be some sort of connection between what you are qualified to be an expert in and the opinion that you have actually given. And in this case, there is a disconnect, I would submit, between the idea that being a pastor automatically makes you an expert on credibility of these two broad classes of people.
Yeah, but look what he says. I mean, and now I'm reading from it. I'm a pastor, and I've dealt with all kinds of things like that. And he repeatedly says, as a pastor, I deal with this on a daily basis. And I know they're pretty good at spinning the truth, so to speak. I've dealt with a lot of these people. I've dealt with that. And then he goes on and on and on. But he invokes his role as a pastor. Now, what you're saying, I think, is that, well, pastors aren't really experts in credibility. But would a juror think that when the pastor repeatedly says, I'm a pastor, I've seen this, and this is the conclusion that I reach?
No, Your Honor, I would disagree with that. And I say that for a couple of reasons. First, I think someone who holds themselves out as a professional or an expert of some sort, we should not assume, and we should give our jurors in Iowa greater credit than to think that they automatically accept that person's statements, not only as their own opinion, but such as their own opinion that they would then disregard the numerous jury instructions, numerous statements that they should decide the case based upon the evidence. And so that, I think, is the distinction between what the pastor did here. There's nothing that's been shown that they did talk to one other juror specifically who said, no, that did not affect my opinion. And actually, when we look at, did what he said affect anybody, right after one of his lengthy passages, the prosecutor specifically turned to another juror and said, if you were to render a verdict today, what would you say? And she said, I don't know, I haven't heard any evidence. So I don't think the record reflects that anybody in this jury pool accepted what he said as fact.
How much leeway should we give the trial judge? Isn't this, or shouldn't it be, an abuse of discretion standard? Because the judge is there, the judge can read the room, he can see the jurors, or the rest of the panel. Are they nodding along? Are they looking reverently at this pastor? Are there eye rolls? Are they ignoring him? What is our standard of review?
I do think it's an abuse of discretion standard, and if we look at the jury selection transcript, we do see several times that the district court explains how he was watching the other juror. He was watching the other jurors. He was picking up on,
Is the judge a mind reader? I mean, how does he know what these other jurors are thinking? You may have it on the one, but of course, if there's one biased juror, that's enough to cause a due process problem. So it may well be that we know that one juror was not affected, but what about the rest of them?
Well, the district court said when he was explaining his ruling on this that by watching the jurors, he did see there was not just the one, there were multiple that were voicing disagreement or that had said throughout the jury selection process, I will decide this based on the evidence. I haven't made a decision yet. I know there were at least 2 jurors that were asked, have you made a decision yet in this case? And they said no because of the evidence. Now, I think...
Well, now let me go back to something. When you say it's abuse of discretion, didn't he raise a due process argument, a fair trial argument here? And haven't we, in the past when this happened, looked at it from a due process argument, which would be a de novo review?
No, I disagree with that, Your Honor, because just saying fair trial does not equal due process, and we also have to look at how did the district court rule upon this? And
But haven't we in the past used a due process standard when we looked at this jury misconduct in these cases?
I am not familiar with that. I do know that the two cases previously talking about this for-cause issue did both look at it as an abuse of discretion standard because of the rule and did not look at it as a due process. That would be Staker and then the Salas case.
And did those cases, are any of those similar to this one where they try to exclude the entire panel based upon prejudice, or are those simply objections to an individual juror who may have shown some type of bias and then wasn't excused? Or
In both the Staker case and the Salas case, it was a request to remove the entire jury panel based on the statements of the one juror. And in both of those cases, they said that is not enough to remove the entire jury panel.
Ms. Huser, often during the jury selection process, a juror might say something to the effect that, well, anyone who's arrested, I think, is guilty. And it's a statement that it doesn't taint the whole jury. But in this case, the pastor went well beyond that, and he detailed something that was far beyond just an expression of his bias against a person, but he explained it by using several different scenarios and stories and talked about the depth of his experience. Do those additional facts, elevate this into the prejudice that the defendant complains about to his right to a fair trial?
No, I don't think so, Your Honor, because I submit this is the same sort of situation that we have whenever there is a juror that comes into the jury panel and says similar things about the brother-in-law that is a police officer, or everybody comes in with some sort of personal experiences and very specific experiences that they share with the jury. And we want them to do that because that is how our parties determine whether anyone might be biased. So I think this is on the same level as if in the opposite example that someone had come in and said, I've had very negative interactions with police officers. I think any police officer that comes onto the stand, I'm going to think is lying.
But doesn't that work against the defendant when the prosecutor is going into such detail about why this pastor believes the way he does, that in the process it adds to the credibility of the pastor's prejudicial statements?
Well, first, I disagree that the prosecutor led the juror into all of these discussions. Looking at the jury transcript, or the jury selection transcript, it was the general questions we see at all of these jury selection type scenarios where we're talking about credibility, what personal experiences make you determine if you believe someone is lying or not. So in that sense, I think those questions were the same as are asked in almost any case. The fact that the juror continued for some length about his personal opinion, no, I think it's on the same level as any other person that has these personal interactions with police officers, people involved with drugs, and we're going to see on our panels opinionated, strong personalities. And
but I think going back to what the chief was saying, to me it's really more than that. It's just the sheer extensiveness of the explanation that does go on page after page. Is there any responsibility of the prosecutor to limit this? I mean, it's pretty obvious after about a paragraph or two of reading the transcript that this person has an obvious bias in this case and shouldn't be on the jury. Is it the prosecutor's responsibility to shut that down, or is it the court's responsibility? Is it the defense counsel's objection, or where does this all fall? Because this is beyond the norm, from what I think is the norm in this type of a jury situation.
To the extent that it was defense counsel that had concerns there was bias being introduced to the jury panel, it was defense counsel's job to step in and halt that. He was concerned that there was bias. I do not think it was the duty of either the prosecutor or the district court to somehow come to a conclusion that this equals bias, we should stop this. I think they could have stepped in, but I think it's the moving party, the party that does think there's a bias issue that needs to step in if they think there's a problem.
I'm going to go back to this standard review. When you read Mock and the federal standards, they say having an impartial jury is a constitutional right under due process, and they examine it under a de novo standard, a due process standard. We have a case called Hodges, where the defendant said, I didn't get a fair trial, and we said that's enough to do a due process analysis. If we decide that there is a due process problem and it was raised, and I don't know what we're going to decide, I mean, does it become a de novo review?
I see my time is up. May I answer the question?
You may.
I am not familiar with the Hodges case, Your Honor. However, it is my understanding what we are talking about is a for-cause challenge, and in the alternative, the motion for mistrial, both of which are an abuse of discretion standard. So I think absent the defendant actually requesting a constitutional review, it should not be a constitutional review.
Counsel, before you sit down, I just have one question. It seems to me, based on the reading I've done so far, there are a couple of primary analytical models for assessing prejudice in these contexts. One would be the model in Mock, where the court makes its own determination of the kind of information that was made available to the jurors, and makes a determination if it was bad enough to constitute what they call a structural error. The other model, the one that I hear you advocating, would require the defendant to put on some evidence of actual prejudice. The problem I have with the model you're advancing is that in the many, many jury trials that I was involved in my former life as a lawyer, I don't recall ever running into a juror who was willing to say, yeah, I don't think I can be fair after I heard that. Because we have this natural tendency to always think as human beings that we can be fair, even when that is reasonably called into question. So would you comment just briefly about the problem that I'm calling up here with respect to proving actual prejudice and actual impact when the jury hears this kind of information?
Yes. In the vast majority of cases, what we have looked at when we're trying to identify this bias is to bring the juror aside and ask them the question, do you think you can still be an impartial, fair juror? And that happened in this very case. They drew aside one of the other jurors and had some conversation with her, and ultimately she did admit that she did not think she could be a fair juror. That happened with the juror in this case who was also removed for cause, the one we're speaking about right now. So I think it would not have been difficult in this case to say, does anyone here agree with what this juror has said? And if anyone raised their hand, to take them aside and question them individually and have them answer that particular question. Thank you.
Thank you as well, counsel. Mr. O'Brien, you may present your argument.
May it please the court. Counsel, there's no way Mr. Airy got a fair trial. Absolutely no way. We would agree that under the normal circumstances, you don't dismiss an entire panel merely because one juror indicates that they have a prejudice. This case is the exception to the rule. was so flagrant. He went on and on and on and on, and the prosecutor kept talking with him about all drug dealers. None of them. They're all guilty. They all lie. How could a panel not be influenced by that?
But if you try these jury cases, and I've probably tried as many as anybody, I mean, this happens all the time.
Of course it does.
And why is this different from any other case? And what was the obligation of the defense counsel to stop this and to figure out what was going on? I mean, Ms. Huser said he never explored any of this stuff.
Well, he tried, Your Honor. He made a motion.
Did he ask for an in-camera hearing to question each juror rather than one he may talk to about whether they were prejudiced?
In a perfect world, perhaps he should have done that.
Well, are we dealing with ineffective assistance of counsel then?
We may potentially be, but I don't think so. I think we can resolve this at this juncture. I think the Court of Appeals majority got it right when they said the standard of review is kind of a hybrid. It's kind of like in the cases dealing with venue issues, where you take a de novo review and then decide, did the trial court abuse discretion?
Well, are you making
De novo of the facts, you mean?
Correct.
But then you still, to that de novo review of the facts, apply abuse of discretion, right?
Exactly.
Well, in the Webster case, just last year, the last time our court examined and reviewed rulings on whether somebody got a fair trial because of juror conduct, the jurors Facebooking, and the jurors were questioned individually. But we applied an abuse of discretion standard. Why shouldn't we do the same here?
Irrespective of what standard you apply, there's no way Mr. Airy got a fair trial here. I mean, really. When you have a past...
I guess I'm just going to take exception to a blanket statement that way, only because there needs to be some evidence that there is some prejudice here beyond the mere fact that we have a rather lengthy exhortation about what this person's personal bias is. Doesn't there has to be some evidence there that somebody else was affected by this, without just assuming that there's been some type of prejudice or poisoning of the entire panel, or one person on the panel, I think is really the more accurate standard.
And I think that's the approach that Judge McDonald took in his dissent. However, I think the majority opinion, and because this is such a unique situation, and the odds of this happening again and reaching the appellate level is fairly slim, in my opinion, mainly because these kinds of issues, when the trial court says, wait a minute, get a new panel, it never gets this far.
Well, let me explore this. I mean, I think your best argument is that it's a structural error, and we've held in Moots, which is only 2 years old, that if somebody sits on the jury that is biased, it's a structural error, and you don't have to show prejudice. I mean, we've said that, and that's pretty simple. But the problem I have is, how do we know these other jurors who were retained, who stayed on the jury, were biased? I mean, I hear the questions from my colleague, if they're not biased, they're not out, but I don't think that's the issue. I think the real issue is, how do we know under this record those other people were biased? Because I think Moots is pretty clear. If someone sits on a jury who was biased, it's a structural error. But how do you get to that point to tell me and tell my colleagues that once this guy was thrown off, that the rest of the panel was biased? And that's the problem I'm having.
And I understand that. And, the mock situation, they just said, hey, we're just presuming, based on how flagrant the statements were made. I mean, it's like the old manure in the milk pail thing.
But mock is sort of a case that has the facts and a conclusion, and I don't know how they got there. We have a record where there was more voir dire, there was in-camera voir dire. The judge asked, do you want to talk, both parties, do you want to talk to any other jurors outside the presence of each other? And you're lower, you weren't there, I'm not going to blame you, but counsel for this defendant said no. I mean, isn't that the time when you go in there and try to figure this out? I mean, the court gave them the opportunity. It wasn't like they weren't down this path. I think they talked to almost 8 or 9 jurors in camera.
Right, and I would submit that this is perhaps a situation where a trial judge, seeing that this is going on, just puts a stop to it. Because
Well, he did.
There
He
was
did
no
after lunch, didn't he? He did. He said, "I'm not going to let anybody talk to this whole jury until we straighten this mess out." But isn't that your client's attorney's obligation?
well, that would be an argument, no question about it, and then we're here on post-conviction relief. As it is, this case is going back for a resentencing. The state agrees. The only issue is whether or not he's going to get a new trial based on the jury panel. And I would submit that the Court of Appeals majority in this case got it right.
Well, I have a little bit of a problem with a lot of these federal cases, that, including Mock, you know, because in Mock, any error that's created there is created by the trial judge himself, because, you know, in federal court, they do all the voir dire, or a lot of the voir dire themselves, I understand, because I never really did a lot of federal work, but it's clear from the Mock case that this is the trial judge, him or herself, who elicits all these things. They ask all the questions, including, you know, that she had the expertise, so she was really, he was asking her to testify almost as an expert. Then he elicits 4 separate statements that she had never been involved in a case where a child victim of sex abuse ever lied. I mean, it's so distinguishable to me. Plus, it's the person who's creating the problem, which is the trial judge themselves, which also leads me to another issue or problem. Do we give any credence to that if we're now looking at more of an adversarial process where you have a prosecutor or have a defense counsel, they're eliciting that, you have the judge who's there to watch and observe?
And that's
not a very good question.
And I understand this is a difficult thing to decide, and that's why it's with you.
But didn't Mock turn on the, you know, I thought Mock turned on, and maybe I'm wrong, I'm not right all the time. Hardly ever, I tell you the truth, if you ask my wife. But the real thing is, you know, after this judge got herself in a hole in the Mock case, the judge then said, "Does anybody disagree with this?" And no one raised their hand.
Well,
I mean, and nobody, and that's nothing like the questioning in this case. I mean, I mean, factually, I think you got a problem if you're relying on Mock.
Well, it's a comparison. It's the same sort of flagrant thing where you have one panel member professing to be an expert, going on and on and on and on about how all drug dealers are liars, how they're all guilty, how they all spin a tale. If you're on that jury panel, how can you not be influenced?
But how is this any different than a nurse on a medical malpractice panel or a policeman on a car accident case? I mean, when you ask the questions, you know what comes out. Maybe you don't know, but I know what comes out of their mouth. So how is this any different?
Well, those folks aren't, that's a money issue, and this is, Mr. Airy spent a lot of years in prison. In fact, he's got 62 years at the moment. That's the main difference because of the constitutional fundamental fairness afforded criminal defendants as opposed to civil defendants who are just fighting over money.
Is it important in our analysis that this prospective juror was a pastor?
I think so. Or,
Why?
or someone, he put himself as an expert in dealing with these folks. My 61 years, I'm 61, and I've been doing this for 40 years, and I've seen all these kinds of people, and they're all liars. In fact, we even had this kid that stole this money. You know, he describes his sting operation. And
All right, and I'm with you. But why isn't the solution at this point to say, look, and tell the jury, this juror has been disqualified for cause, and the statements he made are not evidence in this case? Oh.
And that wasn't done, though.
Well,
That's the
and whose
problem.
responsibility is it to, fair enough, but whose responsibility is it? Why didn't defense counsel should have raised the objection? I mean, I read this, and as I'm reading it, you know, it does go on and on and on. And I think that, frankly, the state has a bit of a problem here because it's not just a snippet. It's not just an occasional statement of bias. I mean, it goes on and on and on. But I'm kind of looking at where's defense counsel? It seems to me after the first paragraph here, I'm looking, at my transcript here, it goes on for 3 or 4 pages. It seems to me after the first paragraph, defense counsel's hair should have been standing up.
And perhaps it was, but perhaps it was the kind of situation where, what do? May I approach the bench, Your Honor?
Absolutely.
Absolutely. What's wrong with that?
And that's something that perhaps should have been done, and then that's something that, in the event that the Court of Appeals is not affirmed here, we would ask that that issue be preserved for post-conviction relief.
I mean, don't you agree that there would certainly be some circumstances where the statements that are made by the prospective juror are so facially kind of preposterous and self-serving and self-aggrandizing, and the person is coming across like a blowhard that the other jurors aren't going to be affected by them?
So true.
And why isn't that the case here?
Well, this pastor made a point how not only was he a pastor, he had 5,000 people in his congregation, and he had 10 associate pastors working for him.
And can't you just see in your mind as you're reading that the other people in the room rolling their eyes?
Maybe, maybe not.
But the trial judge is there. Isn't he or she, the trial judge, better positioned to make the call than we are just reading the printed words?
Well, and that gets down to what standard of review do you want to use? Do you want to use de novo, the hybrid standard that the Court of Appeals majority used, or just a plain abuse of discretion? And then we get back to all the rules about, that you're talking about.
Counsel, would you care to react to the question I posed to opposing counsel about the feasibility of getting jurors to admit that they are unable to be fair?
That is really difficult to do. Jurors, at least we've all had the experience, and how many of you, you walk in and you say, well, how many of you think this defendant is innocent? Will anybody raise their hand? Kind of deal. They're very reluctant to do that.
So is that the
Okay, but
basis,
that's
is that
the
the
point.
reason why you advocate the structural error kind of framework?
Yes, Your Honor.
Can I ask a question? Well, how does it help your case when the juror right after this pastor said just the opposite?
Exactly. And,
I mean,
and they
so
gotta-
now you got another person giving another view, and that's, when you pick a jury, you want views from both sides, sort of, and this person wasn't buying it.
The Court of Appeals jumped right on that, the majority opinion, and noted how the prosecutor, when he heard that, sort of admonished that juror for juror nullification, because this particular juror believed that drugs ought to be legalized. And then on the other side, when Pastor Weaver starts talking, tell me more, tell me more.
Well, but I think, at least my reading of the record on this as well, is that it's not so cut and dry that way. We're talking about determining the credibility of witnesses. That's what leads into all this information, is how do we determine, how is you as a normal person, which is common in jury selection, how do you determine who's telling the truth and who's not telling the truth? All this develops out of that question about credibility. So it's not really unusual to then say, well, this is how I do, body language, whatever you want to say. This person just happens to be able to expound, quite lengthily on this might not be a word, but with a great deal of length. But by the same token, this is the adversary process that we have, which allows, well, can you explain that? And that's what the prosecutor does here. Well, can you explain it? So he gives the example of the kid stealing the money for the pop. I mean, this is not uncommon that you're going to allow quite a bit of latitude in jury selection to let them talk, because you want to be the friend of the jury, whether you're the prosecutor or the defense counsel. So I don't see what's wrong with allowing them to go ahead and proceed, as long as it's not improper.
Well, the Court of Appeals majority felt it was improper under the unique facts of this case, and I would submit that, when in doubt, trial judges should take a conservative approach. It's better just to get a new panel and not run into these kind of problems down the road. And,
But does the better approach make it reversible? And we got a lot of cases where we say what's the better approach is, but, do we require a new trial as a better approach? Or maybe next time someone reads this case may figure out it's a better approach if we decide against you.
all I can suggest is this is such a unique situation. An opinion can be drafted for these unique facts. Because things like this don't happen that often where it gets this flagrant, and that's what the Court of Appeals majority was focusing on. I'm out of time. Thank you.
Thank you as well, Counsel. Ms. Huser, you may present your rebuttal argument.
I have just a few points for the court in my rebuttal.
Before you get there. They're laughing. Before you get there, the way I read moots, and that was a reverse Bastion challenge where they left someone on who should have been off, and we said it's a structural error to leave someone on the jury who is prejudiced. Okay? And I don't know if you agree or not agree with that with your argument, but if we were to find that this panel was prejudiced, how do you distinguish her from moots? I mean, I know you make the argument they weren't, but if we find that, you know, sort of like that's what Mock did, the Court of Appeals found this panel was prejudiced. And they didn't get to the structural, they didn't go that far. But we've said in moots, when somebody sits on a jury who shouldn't be on there, who you had a right to take off, and it's only a 2012 case, how do we not say it's a structural error and grant a new trial?
Well, I think there was a difference between moots, and I'd draw the court's attention back to Neuendorf on the difference in the prejudicial standards for those two cases. Moots was a peremptory challenge, and then prejudice was presumed, whereas Neuendorf, we do not presume prejudice, because it's possible that if you removed a particular jury, you would nonetheless have an impartial jury. So
but that's what we said there. When you remove a jury, you have to show prejudice because you presume it. But when you don't, we distinguish that case. We said when you don't remove a jury, and that was the whole discussion on the last page 224 on, we said when you don't remove the jury, when you don't remove the juror, we say it's a structural error. And we made that distinction. So, you know, you're right. If you don't get it and the person's off, how do you prove the rest of the panel's bad? But we said when the person's on there who shouldn't have been on there, we're going to presume prejudice and make it a structural error.
I think if this court does come to the conclusion that there was a partial juror that sat on this jury, then yes, that is not something we can overcome. But you would have to get to there being a biased person on this jury, which I disagree that has been shown based on this record.
And I agree with you, but if we get there, I think we have to deal with moots, because we distinguish from the case where you don't get your peremptory and someone does, and someone else sits there. I understand that, and that was overturned a few years ago anyway. That's really new law. But regardless of that, what would we have to show or come to the conclusion that this panel was biased? I mean, you say it's not there in this record. What will we have to have?
I think you would have to have that the jury, the individual jurors, were actually asked the question of whether they could come to a conclusion based purely on the evidence and set aside anything else that might have found them to be biased.
And if a juror said no, they'd be out for cause, right?
Yes.
So the only jurors you have left were the jurors who would be presumably unbiased, right?
Correct.
And is that a problem that maybe defense counsel didn't perform effectively rather than for us to presume all this stuff?
I think the record is not here. That is correct, because defense counsel did not object at the time to either the statements that were made by the pastor, if he had a problem at the time, and also that he did not ask to individually question these jurors to see if they were biased based on that other statement.
I mean, would you agree that there might be some cases where you don't have to get an admission from a potential juror, an individual potential juror, that they can no longer decide the case fairly?
I would agree that in a very rare case, on very specific facts, yes.
I mean, suppose, for example, a potential juror said something like, this defendant, I know him and he sexually abused my daughter 10 years ago. I mean, that would be something maybe that would be a different case, right?
Yes, and I think that ties back to the Pascal case from the Fifth Circuit that I cited in my brief, where when you do have these specific facts about this particular case, then that is something we are much more concerned about. And that comes up in our publicity cases as well, the pretrial publicity, where we do have concerns. If there's evidence coming in about this specific case, we may have concerns that the jury is biased.
Well, I think that's right. And there's a case out of Ohio that stands for that proposition, and a number of other cases. So you make a fairly valid point. The problem I have still, though, is in this particular case, it wasn't just, as I've said before, a general statement of bias. This is really extraordinary. Pastor, the person you trust, the person who has confidential communication, presumably, I think an average juror would think that. So the pastor in his pastoral capability, he's listening to people, and they're all liars. Isn't that fairly extraordinary? It doesn't put the bell on Mr. Airy, but it's a pretty extraordinary statement, no?
I see my time is up. May I answer the question? Thank you. I would first disagree with the characterization that purely by being a pastor, we then assume that everyone on this jury suddenly decides, I will accept anything that this person says because they are a pastor. And I say that also because when you look at the statements that this particular juror made, he says that at one point he says it is based on personal experiences. And yes, in his professional life, he has interactions with lots of people, but that is no different. I think the length, as you mentioned, is different of his comments, but what he actually says is no different from any of the other people who come in there as professionals, bank loan officers, teachers.
Oh, no, he says, I have never pastored a person that was accused of any type of drug possession, that wasn't guilty.
But what he also says, Your Honor, if
maybe nobody would believe it, but that's what he said.
What he also says, Your Honor, if I may, is that he came to that decision because he talked to other people that knew that particular person. So it's not necessarily this specialized knowledge of being a pastor that led him to that decision. It was, other people have told me these people are guilty. And I think that that's very different from this idea that perhaps he had some sort of specialized knowledge, skill, etc.
I've worked with lots and lots of people, and I've never known a case where someone was falsely accused of possession or using delivered. Never once was it true. Just reading.
I agree that that was what was said, but I think, again, we go back to what is it as a pastor that we are going to presume and assume that everyone on that jury panel took that as authoritative. And I do not think that it reached that level. Thank you.
Thank you as well, Ms. Huser. The case of State of Iowa versus Kenneth Airy is now then submitted to the court for its decision. Before asking the bailiff to adjourn court, I would only want to make a brief comment basically about you. We appreciate very much that you did take time from your evening to spend it with us. It was Thomas Jefferson that said 230 some years ago that the process of government in this country functions the best when it is understood by the public. And I think your attendance tonight would be very pleasing to Jefferson. As you can tell, each case tells a story, and oftentimes these stories require the application of various legal principles to reach a resolution. And that is what we will now do. It'll result in a final written opinion, and if you're interested in following along, you can go on our website, and it will announce at some point when that decision will be filed, and you can read it online. We look forward to joining you for a reception immediately following the proceedings, and the reception is in the media center of the high school. Thank you again for being here. With that, I would ask the bailiff to adjourn court.